Okay, ladies and gentlemen, let's go ahead and get started if we could please. Allie Forsman, you're going to help us with Robinson versus Omer in a minute. Miss Ikwazi, can you help us with First National Bank of Louisville versus Brooks Farms when we get to it? Yes? No? Maybe? I'm sorry? Yes, we're doing defamation, but we're finishing up negligent infliction of emotional distress. We're picking up where we left off last time. Stones River Motors versus Mid-South. Daniel Bullington. Where are you? What did you say?
I said I'm not prepared for this today. I think we're too fast.
Mimi Herring. This Herring. First National Bank versus Brooks Farms. John Maddox. Sullivan versus Baptist Hospital. Miss Joyce, what about Hustler versus Falwell? That's all I can ask. And if we don't get to that one next week, tonight, we will next week. All right. So last time we made it through the first of the three torts having to do with misrepresentation, that is, intentional misrepresentation or fraud. And so where we need to start tonight is with the close cousin to intentional misrepresentation, which is negligent misrepresentation, where liability rests upon an unintentional but negligent misrepresentation. So even though the defendant may have honestly believed that what he was saying or representing, more accurately, was true, and therefore lacks scienter, so there can't be any liability for fraud. Even though he honestly, in his heart of hearts, believed that what he was representing to the plaintiff was true, he may have been negligent in failing to exercise reasonable care in arriving at that conclusion. And so if that is the case, liability rests upon the failure to exercise due care or negligent misrepresentation. Now, the good news here is, as far as the elements go, the elements for negligent misrepresentation are the same as they are for intentional misrepresentation, with one major exception. And that is, instead of that scienter requirement that we talked about last time, the plaintiff is going to have to prove that the tortfeasor made the misrepresentation without exercising reasonable care for its truth. In other words, the defendant was what? Negligent. Other than that, which is a big difference in and of itself, other than that, the elements are all the same when it comes to intentional misrepresentation / fraud and negligent misrepresentation. As far as the scope of liability is concerned, we talked a little bit about this last time in connection with fraud, but the same issue has come up in courts all across the country when dealing with negligent misrepresentation. And that is, if the tortfeasor makes the misrepresentation negligently to one person, but some other third person over here uses and relies upon that information to their detriment, can that third person recover for negligent misrepresentation? Thinking back to last week, what was the answer to that question when it came to fraud? Yes, provided what? Provided that it was reasonably foreseeable that a third party would use and rely upon that information to their detriment. So that was the rule for fraud. It is the same rule for negligent misrepresentation. And that is the Bethlehem Steel case, right? That is what the court grappled with in that case. And so that's an important similarity between intentional misrepresentation and negligent misrepresentation. Where the two torts part ways, significantly part ways, is that scienter requirement, which is a required showing in a fraud case, but not in a negligent misrepresentation case. So in some ways, these two torts are alike, but in other ways, they're quite different. Let's take a look at Robinson versus Omer now, a case involving negligent misrepresentation. Ms. Forsum, tell us about this case. Yeah, why don't you do that? And actually, you can use that podium right there.
So, defendant James Omer was an attorney in Nashville. He represented Dewey Lineberry, who was a businessman who did a bunch of real estate transactions in the area, including constructing and managing businesses and large buildings.
Can you all hear back there?
Okay. Is this better at all?
Maybe I'll switch places and you do that for me.
No.
Okay. Okay. Defendant James Omer was a lawyer out of Nashville. He represented Dewey Lineberry, who was a real estate businessman. He owned a bunch of big buildings in the area, including office buildings. The one at issue in this case is a building that he had constructed from scratch. And on the third floor of this building, there was a gym with a bathroom, which was opposite of an office with a two-way mirror. Let's see. William Robinson was a contractor and he was a friend of Dewey. And he helped build the building, but also reported for Mr. Lineberry. sexual interactions between Mr. Lineberry and various women from the years of 1986 to 1993 to prevent potential rape allegations.
Okay. Before you get any further into the facts, what's the relationship between the three people that you just mentioned?
James Omer was the attorney for
Right.
Mr. Lineberry.
Say, what's that again?
He was the attorney for Mr. Lineberry.
Okay.
And Mr. Lineberry was friends with Mr. Robinson, and Mr. Robinson was his construction guy, basically.
Okay.
Robinson and Omer really didn't have a connection, other than Mr. Lineberry.
Lineberry is Omer's client. Robinson is not. Okay.
So Robinson operated the camera from 1986.
Back up a little bit more
Okay.
before we get to the. What was the communication between these parties? What which who talked to who and about what?
So Mr. Omer corresponded with Mr. Lineberry about the building and construction of this office building, and allegedly told him it was permissible to have this two-way mirror between the gym and the office, which is his office. That's disputed by Mr. Omer, but for purposes of
And I think that's a good point right there. According to the lawyer, this never happened. This conversation, all this back and forth, this never happened. But because of the procedural posture that this case is in, the court has to assume, for sake of analysis, that it did happen. But if this case were to have been tried on the merits, Omer would have testified, I never gave this advice. No reasonable lawyer would give that kind of advice. To secretly videotape a sexual encounter because it's somehow akin to keeping a diary, Omer would have said, that's nonsense. I never said that. Okay, and so the allegations taken as true is that information was relayed to his client, Lineberry. Then what happened?
Then Lineberry passed that along to Mr. Robinson, who
All right.
proceeded to record the interactions.
Well, before that, what happens? Something very important factually. Lineberry tells Robinson what his lawyer supposedly said. Robinson is skeptical. So what happens? You got 100 bright colleagues. Call on one to help you out.
There was a call where Omer was, I guess, on speakerphone or something like that, and Robinson had heard.
Right. So Robinson was like, I'm just not sure about this. And Lineberry says basically, oh, well, I'll just get my lawyer on the phone. And he does that. Lineberry tells Omer, Robinson is right here in the room. So tell him what you told me. And Omer supposedly says, yeah, it's legally permissible to do this. It's like keeping a diary. Now what happens?
It goes on for several years, and then Robinson.
So Robinson agrees to act as cameraman. And this goes on for, how long did you say?
7 years.
7 years. This surreptitious videotaping. 7 years. Then what happens?
Omer, at some point, the lawyer, decides this is no longer okay, and he informs the district attorney's office about the camera room. And then law enforcement gets a warrant, discovers the videotapes, and while charges were not brought, they contact the women, the victims of the case, and a bunch of the women sue Lineberry and Robinson for invasion of privacy.
Okay, what caused Omer and his client to get sideways? What, they had a falling out. What was that about?
He filed a complaint against him with BPR, the Board of Professional Responsibility.
Okay, Lineberry filed an ethics complaint against his lawyer. What was it for? How come? So everything's chugging along for 7 years, and then all of a sudden, lawyer and client get crossways with one another, with Lineberry filing an ethics complaint against Omer, alleging what?
That, anybody? You know?
Is it because of the referral fee for that big settlement?
So according to Lineberry's ethics complaint, he had an agreement with Omer that if Lineberry referred personal injury cases to Omer would give him a kickback, which, as you maybe don't know, and would, I guess, have no reason to know at this point, that is unethical. Lawyers cannot do that. You cannot split a fee like that with a non-lawyer. That's illegal. It's unethical. You get in a lot of trouble for doing that. So Lineberry alerts the Board of Professional Responsibility that he and Omer had this arrangement, and Omer did not follow through by paying him what his cut would be for personal injury referrals. What does Omer do in response?
He turned him in to the police.
He says, I'll show you. You're going to report me to the BPR? Well, watch this. And so Omer alerts the DA that all of this secret videotaping is going on in that construction building over there, and there's this secret camera room. And the DA is like, oh, really? And gets a search warrant, finds all these videotapes, finds the camera room, and now it's all public, right?
Yes.
And as you point out, some of the women sue both Lineberry and Robinson for any number of different torts. Robinson settles the claims against him, and then what happens?
Omer moved, no, sorry.
Robinson settles the suits against him, and then what is his next legal step?
Robinson then goes and sues Omer for disclosing to the DA that this happened, and then says that he relied upon the advice of counsel that he gave Lineberry.
So Robinson sues Omer for what tort?
Negligent misrepresentation.
Negligent misrepresentation. You just can't make this stuff up. You just cannot make this up. At various points in history, I've had in here is a student, the children of Robinson, the children of Lineberry, and the children of Omer. Had them all.
In the same class?
No, different points. But at each point, discussing this case was somewhat sensitive and had to be finessed in some ways. That's always an inherent danger when you use Tennessee cases to illustrate and think about the law. It's a pretty small world. Okay, so Robinson sues Omer for negligent infliction. Why am I stuck on negligent infliction of emotional distress? I'm really not sure. But he sues for negligent misrepresentation. And you saw that the court's analysis rose and fall on the application of Section 552 of the Restatement of Torts, right? Which provides for what?
It has 4 points. It says the defendant has to be acting within the course of his business, profession, or employment, or a transaction where he has fiduciary interest. The defendant supplies facts.
Pecuniary interest, which means just an economic interest.
The defendant supplies false information meant to guide others in those business transactions.
Yep.
The defendant fails to exercise reasonable care in obtaining or communicating that information, and the plaintiff justifiably relies upon that information.
So in that one section, that one sentence of Section 552, if you break it down into its component parts, you come up with the elements of negligent misrepresentation, right? All in that one sentence. And so the issue before the court here is whether Robinson has met the requirements of Section 552. Or to say it a little differently, and more simply, can he recover for negligent misrepresentation against Omer?
In this case,
No. No. Why not?
because the advice he was relying on was not relevant to the actions that were taken. The advice that was given was about a different business, and this was not a business transaction. He accepted no money for the recording. He did it as a favor to a friend. It was not business advice.
In fact, his own testimony was business interests never crossed my mind. And I'll bet it didn't. But that testimony right there killed his case. This had nothing to do with business, nothing to do with money. No pecuniary interests are involved here. I did this as a favor for my friend. And business interests never crossed my mind. That's why I acted as cameraman for 7 years. Case dismissed. What's the takeaway for you, legally speaking?
Be sure about the legal advice you're giving and make sure you know who you're giving it to. I think it's a big one.
You know, when you read this case, was something maybe a little deep down unsettling when you figured out, okay, a lawyer is getting sued by a non-client, someone that he never even met, never had in his office? That's a pretty sobering realization. That the advice that you give to your client potentially you can be held liable by a third party if it's reasonably foreseeable that that third party might use and rely on that information. I mean, as a professional person, doctor, lawyer, accountant, whatever, you know you have certain obligations that run from you to your client, and you know that and accept the fact that if you screw that up, i.e. you commit malpractice, you can be held liable to your client. That is just part and parcel of being a professional who gives advice or provides a service in the case of a healthcare provider. But what makes us really uncomfortable is the fact that our potential liability doesn't stop with just the person we know, the person that is in the office or under our care. It can extend to these third parties. It just so happens in this case that the facts didn't fit the requirements of Section 552. Thank you, ma'am. Well, some courts take all of this a step further and will impose strict liability for misrepresentations even when the falsity is unknown to the tortfeasor. And even though the tortfeasor may not have deviated from a standard of reasonableness. And so liability for misrepresentation is strict. It's absolute. And this third version of misrepresentation is called innocent misrepresentation, which is an apt description, right? Because the tortfeasor did not have scienter, and he wasn't negligent. He made the misrepresentation innocently. But yet, under certain circumstances, can be held liable. And that brings us to the second case, First National Bank versus Brooks Farms. Ms. Herring, tell us about this one.
Okay, I was a little bit confused on this, so I might need some help, but I'm gonna do my very best. Okay, so the case involved Brooks Farms, a dairy farmer, which purchased Harvestor silos from Hermitage Harvestor Systems, which they were the dealer, and A.O. Smith Harvestor Products, the manufacturer. Brook Farms alleged that the silos were defective, and both the manufacturer and the dealer made fraudulent and innocent misrepresentations about the silo's ability to preserve feed without oxygen contact. These misrepresentations were made through advertising brochures and promotional films. Brook Farms claimed that the silos did not preserve feed as promised, resulting in reduced milk production and profits. The purchase order signed by Brooks Farms included disclaimers stating that the buyer had not relied on any representations made by the dealer or manufacturer. However, the jury found that the manufacturer made intentional misrepresentations.
Okay, before we get to that point, what did the dairy farmers sue the manufacturer, A.O. Shippey, and the seller/dealer of these silos for?
Misrepresentation on their oxygen.
Well, misrepresentation includes 3 distinct torts. Did they sue for all 3?
I don't think so.
They initially sued for all 3 along with a host of other claims. But as we have seen in other cases, as the litigation progresses, the lawyers try to winnow down the various causes of action and thereby focus the case and try to make it as easy for the jury to decide as possible. So, although this case starts out by throwing everything imaginable against the wall to see what might ultimately stick, prior to trial, the dairy farmers or the lawyers decide, let's get rid of all, let's abandon all of our claims except innocent misrepresentation, negligent misrepresentation, and fraud. When the case is actually tried, they winnow it down even further. And so which of the misrepresentation claims are actually submitted to the jury?
Was it fraudulent and innocent?
Yes, it was. You see, the plaintiff's lawyers decided to cut out the middleman, negligent infliction. Why am I stuck on negligent infliction tonight? I don't get that. The dairy farmers decide to go to the two extremes, as it were, leave out the middle option for the jury, negligent misrepresentation, and take a risk on fraud, and in the other end of the spectrum, innocent misrepresentation. No doubt they're thinking, surely I can get a recovery based on one or the other. So those two claims are submitted to the jury. What's the jury decide?
The jury found AOS HPI guilty of intentional and innocent misrepresentation, and Hermitage guilty of innocent misrepresentation.
And awards a lot of damages, right?
Yes, both compensatory and punitive to AOS HPI.
Okay, and against the dealer/seller as well.
Yes.
One of the issues before the Tennessee Supreme Court is whether the manufacturer did in fact commit fraud and intentional misrepresentation. How did the Supreme Court address or decide that issue? Did A.O. Shippey commit fraud? The jury said that they did.
Yes.
Yes. Okay. So the Supreme Court agrees with the result reached at the trial court. And my question to you then becomes, what was the misrepresented fact? You remember last week we talked about if you can't put your finger on a fact that was misrepresented, there can't be liability for fraud. So what is the fact that the defendant misrepresented?
The ability to preserve the silo.
So what was the fact?
What do you mean?
Well, what do you mean?
Like, that's what they were making misrepresentations about, correct?
Okay, what was it though, is what I'm asking. What was the fact that was misrepresented?
The oxygen content?
You punctuated that with a question mark. What about the oxygen content? What was the fact?
Oh, it wouldn't use oxygen contact.
That, okay, so oxygen would get into these silos and contact the feed during the loading process, but then would very quickly be consumed and no oxygen would be able to get in the silo. And therefore, the nutritional content of the feed would be maintained. And that is the fact that was misrepresented. The manufacturer of the silo argues that there can be no liability for fraud, even if there was an intentional misrepresentation, because the sales contract that the plaintiff signed, which you alluded to earlier, expressly disclaimed reliance on anything that the defendant may have represented. And as you'll recall from last week, reliance is one of the essential elements of fraud, right? So here the defendant is saying, you signed a document that said you're not relying upon anything that we've told you. Therefore, you can't recover for fraud. How's the Supreme Court deal with that argument?
They said that that's not available in the presence of fraud.
What's not available?
Like if you sign, I think it was a purchase order, that they have the disclaimer, that just goes away if there's like fraud.
So a disclaimer is not legally enforceable if there's fraud. If there's trickery, if there's deceit, the courts are not going to enforce a disclaimer. So in the end, the manufacturer is in fact found liable, as affirmed on appeal, for intentional misrepresentation. It's that part of this case that is unimportant, really, in the grand scheme of things. What makes this case a big deal really isn't have anything to do with fraud or intentional misrepresentation, but innocent misrepresentation. Because the jury also found that both defendants, the manufacturer and the seller, liable for innocent misrepresentation. Which, at least as to the manufacturer, would seem to be somewhat contradictory, right? I mean, why would they be liable for fraud and innocent misrepresentation? If they're liable for fraud in their advertising, stemming from their advertising materials, they intentionally misrepresented information. So I'm not real sure how the jury also deemed that defendant on an innocent misrepresentation theory. But that's neither here nor there for our purposes. As far as the innocent misrepresentation part of this case goes, the Supreme Court granted review to take another look at a 1966 case called Ford Motor Company versus Loanin. And in this 1966 case, the Tennessee Supreme Court adopted Section 402B and Section 552D of the Restatement of Torts. What does Section 402B provide for?
I did not put that down.
Okay, get somebody to help you out there.
One who engaged in the business of selling chattels is liable for physical harm resulting from the misrepresentation to the public of the material fact justifiably relied upon by the purchaser of the product, even though the misrepresentation would not be fraudulently or negligently, and there is no privity contract.
Okay. Under Section 402B, then, liability can be imposed for an innocent misrepresentation, provided there is either personal injury or property damage. That was part of the court's decision back in 1966 in this Ford case. The other part of the restatement that the court adopted in the Ford case was Section 552D. Did you have that one?
No, I think I cut that part, like this main section out completely.
Okay. Well, that's the most important part of the whole opinion. So somebody help her out on that. Section 552D. What is that one about? Anybody?
One engaged in the business of selling chattels who by advertising, labels, or otherwise makes to the public a misrepresentation of material fact concerning the character or quality of the chattel sold by him is subject to liability for pecuniary loss caused to another by the purchase of the chattel and justifiable reliance on the misrepresentation, even though it is not made fraudulently or negligently.
Well, that sounds a whole lot like Section 402B. In fact, the two sections read almost exactly alike, almost word for word. The difference is in section 552D, the phrase physical harm is changed to pecuniary loss. The question then becomes whether section 402B and section 552D, that is innocent misrepresentation, should continue to be the law in Tennessee or not.
I know I skipped most of that, but I'm pretty sure they said it needs to be cut out and they could deal with it with other legal theories.
So let me ask you this. If a plaintiff has suffered personal injury or property damage, can liability be imposed based on an innocent misrepresentation theory?
Yes.
Yes. That's section 402B. The court adopted that in the Ford case, and fast forward to this case, and the court made no changes to that. Now, what if there is no personal injury or property damage and there's only economic loss? Section 552D. Can a plaintiff recover on an innocent misrepresentation theory?
No.
No. And it's for the reason that you suggested, which is if there's only economic loss, no personal injury, no property damage, the rights and responsibilities of the parties can be better addressed by other areas of the law, i.e. sales law, UCC law, contract law. It's not really even a tort case. So the court decides to retain section 402B and write out of existence section 552D. Apply that to the facts of this case. May the dairy farmers recover on an innocent misrepresentation theory based on these facts?
Yes. No. No.
Was there personal injury?
No.
No. Was there property damage?
Yes.
No. It's not like these silos fell over and killed a bunch of cows. No property damage, no personal injury. So that's going to eliminate section 402B. They're only seeking to recover for lost profits. The loss of money, pecuniary loss. That's section 552D, and the court found that you can no longer recover for that on a tort theory. You can sue in contract, sue under the UCC, etc., but not on a tort theory. So bottom line this one for us. What does this case teach you about the law?
That they won't offer innocent misrepresentations for economic loss.
Yeah, that's it. And it's interesting, and the court pointed this out, that from 1966, when the Ford case was decided, until this case was decided, not one single state in the country other than Tennessee had adopted section 552D. And so, figuratively speaking, the court looks around the country when it has to decide this case and it sees that, well, we're the only ones standing. Is there a good reason we're the only ones standing? The court says no. We can't think of one. So we're going to join the rest of the country. And the law is uniform throughout the United States that innocent misrepresentation is not a viable theory when the plaintiff's only damage is economic in nature. Now, do understand that if the plaintiff has personal injury and or property damage, they can recover for that plus economic loss if there is economic loss. It's just that when there's sole economic loss, they can't recover. Thank you, ma'am. I agree. This is not one of our easier cases. All right, let me just run through a couple last points here, and we'll get on to the subject of defamation. As far as defenses are concerned, assumption of risk is a defense in an innocent and a negligent misrepresentation case, but not fraud. Assumption of risk will work in an innocent and a negligent misrepresentation case, but not intentional misrepresentation. Our old friend contributory negligence, to the extent that that one is still around, is a defense to negligent misrepresentation only. And then the big one, comparative fault. And you thought we would never talk about comparative fault again. Comparative fault is not a defense in a fraud case. It is in a negligent misrepresentation case. And it is unknown whether it is a defense in an innocent misrepresentation case. To my knowledge, at least, the law, that's an open question. The courts have not given us an answer. So comparative fault is not a defense in a fraud case. It is in a negligent misrepresentation case. And time will tell whether comparative fault principles apply in an innocent misrepresentation case. Last, let me just make you aware that there is a statutory cause of action in Tennessee for what the statute calls unfair or deceptive trade practices. This is called the Tennessee Consumer Protection Act. You've probably heard of this at some point or another. But for our purposes, the important part of the Tennessee Consumer Protection Act is if the conduct at issue is willful or knowing. It sounds like fraud to me. If the conduct at issue is knowing or willful, then the court can award the plaintiff treble damages. Treble, meaning triple the plaintiff's damages plus attorney's fees. Think back to the beginning of the year when we talked about damages. You remember the American rule? The American rule provides that each side pays their own attorney's fees, right? Win, lose, or otherwise. Attorney's fees are not part of a recovery unless what? What was the exception? What was the exception? Unless there is a statute that provides for shifting fees. And there aren't many of these, but this is one of them. Under the Tennessee Consumer Protection Act, the court can award the plaintiff attorney's fees. So not only will the defendant have to pay 3 times the compensatory damages, but will also have to pay the plaintiff's attorney's fees. So this is a statute that has some real teeth to it. Any questions about misrepresentation? Is it hot in here or is it just me? Remember our understanding, right? You cannot tattle on me. All right, nobody saw what I just did. Hopefully the camera's not on. But it's going to cool down real fast. It was only 77 in here, but not for long. All right, so let's turn a pretty sharp corner here and talk about something that I think you will agree is more interesting than misrepresentation. And of course, that's the subject of defamation. Defamation, just to make a couple introductory points here, defamation is not in and of itself a tort. It is a label term used to refer to 2 distinct torts: libel and slander. Slander, this is an oversimplification, but it works for our purposes. Slander is spoken defamation. Libel is written defamation. We'll get into some distinctions beyond that next week, but everything we talk about tonight, and I suspect the first part of next week, applies to both libel and slander. Basically, defamation, both libel and slander, refer to a false communication about the plaintiff that injures the plaintiff's good name or reputation. That's what every defamation case is about, or should be about. A false communication about the plaintiff that injures the plaintiff's good name or reputation. Unfortunately, however, there are some people who do not have good names and or reputations, and therefore they cannot be defamed. Such persons are defamation proof, as the court in the Davis case found that plaintiff to be. The court determined that his reputation was valueless. How would you like a court to say that about your reputation? That your reputation is so bad, there is nothing there for the law to protect. And therefore, you are defamation proof. That was the court's holding in Davis, that plaintiff could not recover for defamation because his reputation was valueless. So defamation is a false communication about the plaintiff that injures his reputation, and that presupposes that the plaintiff has a reputation that is worth protecting. The plaintiff must not be defamation proof. That said, there are 6 elements that make up a defamation case, and the first of these is defamatory language. There must be defamatory language, which basically means any communication that would reflect unfavorably upon the plaintiff. Does anybody in here, I know there'll be some, recognize this person? No, it is not Mr. Rogers. He would take great offense if he heard you say that. Anybody know who this person is? The planets and all that in the background should give you a hint. What? Dr. Carl Sagan. A very famous, I know. This is kind of back in the day, but follow me on this. Dr. Carl Sagan is a very famous astronomer. He's deceased now. But he's was a Cornell professor, an astronomy professor, who was very popular. And he had his own television show where he would talk about events that occurred in the most distant parts of the universe. And he just had a way of teaching and explaining events, the planets, and how everything just works together. And his television shows were big hits. He was famous for a phrase that he would use in every show that he did. And that phrase was billions and billions of years ago. So he talked about celestial events that occurred billions and billions of years ago. That was his thing, billions and billions of years ago. Well, he and Apple Computer had a run-in over the use of that phrase, billions and billions. And what happened was Apple was developing some computers and computer-related technology. And as is common in that type of industry, code names, secret code names, are assigned to those projects that supposedly are designed to throw off competitors and keep this developing technology secret. Well, the folks at Apple Computer who were working on this new technology decided that they would name their project after Dr. Sagan, with the hope that once the computers hit the market and were given the name that you and I know them by, it would propel the sales into the billions and billions. And so they named their secret project Dr. Sagan. Someone at Apple leaked this to an industry magazine, and an article was written about it. It said basically what I just told you. Dr. Sagan was none too happy that his name was being used in this way. And so his lawyers wrote Apple Computer a demand letter, a stern letter that says, more or less, you better stop using Dr. Sagan's name in this way, or we're going to sue you for defamation, among other things. Apple says, fine. We'll no longer call our secret project Dr. Sagan. Instead, we're going to rename this project BASIC which stands for Butthead Astronomer. Someone at Apple Computer leaked that to an industry magazine, and at that point, Dr. Sagan had his lawyers travel at light speed to the nearest federal courthouse and sue Apple Computer for defamation. As this case was winding its way through the litigation process, one of Apple Computer's lawyers gave a reporter an interview about the case. And this lawyer, who's defending Apple, says to the reporter, quote, "It is unlikely that butthead will be seen as defamatory. If you refer to someone as a butthead, ordinarily speaking, no one is going to take that as any specific charge of any improper conduct or insinuation of any character trait." And then this lawyer says, the big question that will have to be answered by the jury at trial is, what exactly is a butthead? He's exactly right. What was, in effect, what was he saying? Take what he said to this reporter and translate that into what you just learned about defamation. What must there be? I'll give you a hint. It's the first element that we're talking about. There has to be a defamatory communication, right? This lawyer is saying that's not a defamatory communication. In fact, you can't even define what a butthead is. And if you can't define what it is, it can't be defamatory. So we have this federal case, literally a federal case, over whether it is illegal, that is tortious, to call someone a butthead. And the federal court issued its decision and said that it is legally permissible to call someone a butthead. The court said this: it strains reason to conclude that the defendant, Apple, was attempting to criticize the plaintiff's reputation or competency as an astronomer. One does not seriously attack the expertise of a renowned scientist using the undefined phrase butthead, meaning there is no defamatory language here. And the case was dismissed. So we know that calling someone a butthead is not defamatory language. So what is? That's not tortious to call someone a butthead. But okay, so what is defamatory language? What is a defamatory communication? Several things here. First, the communication at issue is defamatory only if the recipient of that communication, the person who saw it or the person who read it, understood it in its defamatory sense. It's only defamatory communication if the recipient of that understood it in its defamatory sense. Now, let's take that a step further. A defamatory communication might be defamatory on its face, or it might not be. A defamatory communication on its face means you can take just the words that were said or just the words that were written and conclude that's defamatory. That reflects unfavorably on the plaintiff. For example, if A says to B, and falsely so, A falsely says to B, C is a thief because he once stole money from me. That's defamatory on its face, right? You can just listen to those words and conclude that that would reflect unfavorably on C. That's the easy case. The harder cases are those where the defamatory communication is not per se defamatory. That is, it's not defamatory on its face, and therefore the plaintiff has to provide extrinsic facts and circumstances in order to supply up the defamatory meaning. And that's permissible. That type of defamatory language is called inducement. There's just some strange terminology associated with the law of defamation. And this is an example of that. So in the context of defamation law, when you see the word inducement, all that means is that the communication at issue is not defamatory on its face, but it can become so when it's put in its context. When you consider the additional facts or circumstances that the plaintiff presents to the court, now you see how it is defamatory. And that's called inducement. Explaining how the statement is defamatory in light of the inducement is called innuendo. I like to think of innuendo as the implication of the defamatory communication in light of its context, in light of those additional facts or circumstances. So, two terms here that just alert the court and also the defendant that the communication at issue is not defamatory on its face, and so the plaintiff has to go beyond what was said, beyond what was written, in order to supply the defamatory meaning. As far as the form of the communication, it just doesn't matter. The form of the communication, for purposes of this first element, is irrelevant. It might be spoken, it might be written, it might be a picture, it might be conduct. The form that the communication takes makes no difference. What matters is that there is a defamatory communication. It's kind of like in the context, stepping back to fraud, if you can't put your finger on a misrepresented fact, there is no fraud. Well, in a defamation case, if you can't put your finger on a defamatory communication, there's no liability for defamation. No matter the form. How about this question? Just to keep taking this first element further. Does the person who sees it or hears it, do they have to believe it to be true? Or can they know that it's a lie, know that it's false? Do they have to believe it's true? So when A falsely says to B, C is a thief because he once stole my money, does B have to believe that's true? What if B knows that it's not true? What if B says to A, that didn't happen, that's a lie? You know it didn't happen. Is A nonetheless liable to C for defamation? Yes. There is no requirement that the recipient of the communication believe it to be true. The rationale for that is that there are just certain types of defamatory accusations that even if the person hears them or sees them, knows that they're false, it can still damage the plaintiff's good name and reputation. In other words, just having your name associated with child abuse or having committed a sex crime or having stolen something can be harmful to someone's reputation, even though it turns out that that is just flat wrong, right? Just having your name in the same context of, oh, child abuse, even though it's wrong, it's incorrect, and the person that sees it or hears it knows that it's incorrect, can still undermine somebody's good name or reputation. And the law recognizes that reality. And hence we have this rule that the recipient of the communication need not believe that it's true. Also, to be defamatory, and very importantly, there must be the assertion of a false fact about the plaintiff, a false fact. So mere name calling, i.e. butthead astronomer, that's by definition not defamatory. It's not very nice to call someone a butthead, but it's not illegal to call someone an ugly name. It is illegal to assert a false fact about someone. That's defamatory. Name calling is free speech. Where a defendant crosses that line from legally permissible to legally impermissible is the false fact. Now, what if the defendant waters down the communication and states it in the form of, well, I think he stole money from me. I believe he stole money from me. I'm pretty sure he did. Or it's my opinion that he did. Is there a blanket First Amendment protection for statements of opinion like that? The answer is no. Statements of opinion can constitute actionable defamation as long as there's an express or implied assertion of a false fact. So no, just because the defendant waters it down and instead of saying to A saying to B, C is a thief because he once stole money from me, if he waters that down and says falsely to B, I think he's a thief because I believe he once stole money from me, that's still actionable defamation. You see how that's different from just, well, you're a butthead. Sometimes, as you can imagine, it's difficult for courts to make these very fine line distinctions. But that's why we have courts, right? That's why we have juries. You put 12 reasonable people in the box and you let them figure it out. Last, as far as this first element is concerned, courts have had to decide who can be defamed. We've already talked about if the plaintiff is defamation proof, they can't be defamed. But other than that, can a deceased person be defamed? No. So the rule is any living person can be defamed, again, assuming they're not defamation proof. Now, it may not be very nice to say ugly things about the dearly departed, but it's not illegal to do that. It's not tortious. It's not defamatory. So any living person can be defamed. Also, businesses can be plaintiffs in these cases. Businesses can be defamed. In fact, if you just think about it in real world terms, for most businesses, the most valuable thing that they have is their reputation, right? And the law recognizes that fact. So sometimes you'll see a business serve as a plaintiff in a defamation case. So any living person or any business. The second element, the second requirement is that the defamatory communication must have been understood by the recipient as referring to the plaintiff. I call this second element the other concerning requirement. That is, the defamatory language must be of or concerning the plaintiff. And just like with the first element, a plaintiff, when he or she gets to this second element, can rely on extrinsic facts and circumstances to show that a reasonable person would and did understand the communication as referring to the plaintiff. That type of defamatory communication is called colloquium. Another of these strange terms, colloquium. So when you see that in a defamation context, it just means that the communication at issue did not actually use the plaintiff's name. If it does, so much better for the plaintiff. That's the easy case. But often, the defamatory communication does not name the plaintiff. And that brings us to Stones River Motors versus Mid-South Publishing Company. Who was it that had this case? Okay, yes, you did. Come on up.
If I talk a little, y'all, because I am. All right. So this case, Stones River Motors, it was a business, and it was a used car dealership in Murfreesboro, Tennessee, and the owner, his name was Kenneth Snell. So a customer, his name was Bill Beckford. He purchased a used 1972 Datsun from this dealership and purchased it for $800. And 2 days after he bought the car, it was messed up. It had mechanical problems, and they had to tow it back to the dealership and get it repaired. So that first time, they split the cost, and they were okay with that. But he ended up trading in that car for another Datsun.
An even older car.
Yeah.
And he paid more money for that older car, right? So what happens to that car?
So that car, it ended up also having mechanical problems.
Yep.
And he took it to the dealership. The customer asked if he can get it fixed and for free, and the dealer said no. So that's when they, I guess, got into an issue. So the customer, Big Four, he became frustrated and wrote a letter to the editor, and he was just basically describing his experience with the dealership, and he complained. He wrote several things, but he specifically wrote that it was highway robbery and this guy is a ripoff. And he also said like customers should go to dealers who actually care about customer service rather than profits. And then at the end of the letter, he signed his own name, and then also his wife, and then also his daughter. So.
And all three of them get sued.
And all three of them get sued.
Let's deal with the wife and the daughter first. Are they liable for defamation?
The court said that they are not because they weren't even aware that he wrote all these things. So they eventually got removed from.
So husband/dad didn't even tell his wife and daughter that he was putting their names on this letter. In fact, he didn't even tell them that he was writing the letter, much less that he was putting their names on it. And they found out about it after they got sued. I suspect husband/dad will hear about that for the rest of his life. Well, as far as those two defendants are concerned, the court has no problem dismissing them quickly from the case, right? You can't publish something about which you're unaware. That's common sense. So they're out of the case. Let's deal with one of the two newspapers, the first being the Daily News Journal. Is the Daily News Journal liable for defamation?
They are not because they, one, specifically did not mention him. And the way that they did kind of bring him up was vague, so they don't specifically know that it's this specific dealer. They refer to him as a local import dealer, and that could be anybody in Murfreesboro. So, yeah.
And in fact, one of the editors at this newspaper testified that the very reason we watered down the letter was to avoid being held liable for defamation. And they apparently did their jobs well. It worked. Because the plaintiff could not prove this of or concerning him requirement. What about the other newspaper and Mr. Bigford?
The other newspaper was the Press, and the court kind of looked at them like they could be, just because it was a little bit more specific. They actually, instead of it being vague, they specifically said that same dealer, and this specific dealer was the only person in Murfreesboro that did this, so it could.
So was the of or concerning requirement satisfied as to the Press and Mr. Bigford?
Yes, because somebody reading that could possibly know that it's him.
So yeah, there's no problem here with the of or concerning requirement. Basically, the Press, unlike the Daily News Journal, published the letter as it was. They didn't water it down to make it difficult for a reader to make the connection between the story and this particular car dealership. They just published it as it was. So the of or concerning requirement was satisfied. Does that mean then that the Press and Mr. Bigford were liable for defamation?
Not necessarily, because
Well, leave out the word necessarily.
No,
No,
they weren't.
they're not liable. Why are they not liable?
Well, like we just discussed, he said a lot of things, but I specifically quoted the guys that were involved, and he did highway robbery. And, those are kind of like opinions, and they're not statements of facts. They call it characterizations of the guy's experience. So,
It's akin to butthead. This communication falls in the category of name calling. It is somebody's opinion. Oh, you sold me 2 unserviceable cars, and if you were a good business, you would do right by me as your customer, and you would fix my cars for free. And so I feel like I've been taken advantage of as a customer. You're putting too much emphasis on profits rather than customer service, and I'm mad about it. You're a butthead. That is legally protected speech under the First Amendment. Why? Because there's no false assertion of a fact. If you can't put your finger on a fact, it's protected speech. Remember, you can call people or a business ugly names. Well, that's a ripoff. You're not a very good business. Well, you're a butthead astronomer. You can do that. It's not illegal. Just don't assert a false assertion of fact. That is illegal. That's defamatory. There's a lot in this case, but I'll just ask you, what's the big takeaway for you? Legally, what did this case teach you about the law that you just didn't know?
that if somebody says something that may come off as offensive, if it's not a statement of fact, it doesn't make me liable for what I said. I can be opinionated.
Yes, you can be very opinionated. I like that. In fact, the court says you can express your opinions in very strong and even abusive terms. Not just say ugly things, but say very ugly things and say them passionately. And it's still protected speech. Just don't cross the line into a false assertion of fact. I think that is the big takeaway from this case. Thank you, ma'am. Let's jump down to the next element of publication. In order for defamatory language to be actionable, there must have been a publication. And if you turn off the lawyer part of your brain and turn the layperson part of your brain back on, which I'm not asking you to do in a while, but do it right now. Just turn off the lawyer part of your brain. Just get rid of whatever. Don't get rid of torts, but if you want to flush contracts, criminal law and all that, that's fine. You do that. And you hear the word publication, just as a normal person. What do you think of? That's what I think of as a normal person. I think of something that is like bound together and published. Like, this book, this book is published. I got a novel published. Now turn the lawyer part of your brain back on. And that part of your brain should tell you, after you've read these materials, that is not what publication means in the legal world, right? Specifically in the context of defamation. Instead, publication in this context means that the language at issue was communicated to at least one third person who understood it in its defamatory sense. It must have been communicated to at least one third person who understood it in its defamatory sense. So what if A sees a defamatory statement about B that... Did we just have a visitor? It's probably someone in the office that saw me change that thermostat and came into fuss. It is cooled down now, hasn't it? All right, good. Yeah. If I'm not here next week, it was nice. I've had a nice year with you. Good luck to you. What if A sees a communication about B that is defamatory? It is defamatory, but it's written in a language that A can't understand. Or or he hears it, but it's a language that he doesn't understand. But it is defamatory. Is there liability for defamation? No. Why? Because there's no publication. It was not made known to at least one third person who understood it in its defamatory sense. Now, how about this example? What if A falsely says to B, B, you are a thief because you once stole money from me. And nobody else is around to hear it. Is A liable to B for defamation? No. Why? Because it wasn't communicated to at least one third person. What if the plaintiff is the one who does the publication? Is that a valid publication for purposes of this element? So the plaintiff himself or herself is the one that broadcasts that defamatory communication to the world. Is self-publication a valid publication? That's Sullivan versus Baptist Hospital, right? And that is where we're going to start next week. Make sure I get the roll. I'll see you next week.
Question about the final. Will it be cumulative or heavily